invitation as well as a password for today's proceeding. But that doesn't give public access to today's proceedings. Normally this would be happening in a courtroom, and any member of the public at any time could walk into a courtroom and see what we're doing. So in order to allow for public access to what we do, as a temporary measure, we are live streaming all of our proceedings. So I'm letting you know that I'm doing that. That being said, this is not a record of today's proceedings. If you wanted to have a record, you have to obtain your own court reporter, because the live stream is going to be deleted immediately upon conclusion of the docket today, okay? Let me check in. I've got Midland Credit versus William Collins. Do I have counsel here for Midland Credit? Ms. Schweitzer?
Yes, Your Honor. Carly Schweitzer on behalf of Midland.
Good morning, ma'am.
Good morning.
And Mr. Collins here. I do not have a Mr. Collins checked in. Let's give it just a moment and see if he's going to try to sign it, okay? Thank you for your patience, counsel. I've also got Portfolio Recovery versus Jeffrey Mirin. Do I have counsel for Portfolio here?
Good morning, Your Honor. This is Penny Turner for Portfolio.
All right. Do I have a Jeffrey Mirin present? All right. Is everybody else here for Smith v. Klein? Is everyone else here for that case?
Yes, we're here, Your Honor.
All right. And did either of the attorneys, do you have witnesses present?
I have.
Yes, yes, Your Honor. Josh Abel on behalf for Midland. He's our witness. Sorry.
And Ms. Turner, you also have a witness present?
Yes, Lisa Tickle. She's
All
for
right.
Portfolio. Yes, sir.
All right. Well, let me just make sure that we've got notice. Give me one moment, please.
Yes, sir.
Ms. Schweitzer,
Yes.
you said you're here on behalf of Midland, correct?
Yes, sir.
Back in April, there was a motion to continue filed by Midland because it looks like you were investigating whether this defendant was actually the debtor. Oh, there's Mr. Klein again. All right. Whether this defendant was the actual debtor,
Yeah.
or it was his father. Were you able to conclude that investigation?
Mr. Nebel would possibly know that if I would not know that, but Mr. Nebel works for the company. So did they, can he talk?
Oh, yes, please.
Your Honor, yeah, we were not able to conclude that. We did our internal investigation as well as sent out paperwork for additional information and never received any correspondence back.
Okay. And so does Midland want to go forward at this time, or is there any further investigation you need to conduct?
We would like to go forward. We've concluded everything we can do internally for investigation without any additional information.
And you got no response from Mr. Collins?
Correct.
Okay. All right, the order granting continuance was issued back in April. It was sent to Mr. Collins at his Naples address. It was not returned as undeliverable. So I believe he received proper notice of today's proceeding. It was dated correctly for today at 9 o'clock. It's now 9:10. Counsel, ready to proceed whenever you are.
Okay. Let's see.
And for Mr. and Mrs. Smith and for Mr. Klein, because it sounds like your case is going to take a little bit of time, let me take care of these folks first, and then I can devote all my attention to you, okay?
Okay, thank you.
All right, thank you.
Good morning, Your Honor. May it please the court. My name is Carly Schweitzer, and I represent the plaintiff, Midland Credit Management. We're here today for a court-ordered non-jury trial regarding damages resulting from the defendant's credit card debit with Capital One Bank. Midland Funding has established an account-stated action in which the defendant has received monthly statements. He He has not timely objected to the statements, nor has presented any evidence of fraud, mistake, or error that has not been investigated. Therefore, the defendant has expressly or implicitly promised to pay the balance set forth in the statements. Further, the defendant has not paid the amount owed under the account. As successor in interest to Capital One Bank, the evidence will show that Midland Funding is entitled to recover from the defendant the amount sought in the suit plus costs. Your Honor, the plaintiff would like to call Joshua Nabel.
All right. Mr. Nabel, would you please raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
You can put your hand down, please. Go ahead, counsel.
Hello, Mr. Nabel. Can you please state your name and spell it for the record?
Yes, Josh Knebel. Its last name is spelled
Oh.
K-N.
Sorry, I mispronounced your name, sir.
That's okay. Last name is spelled K-N-E-B-E-L.
Okay.
Okay, and Mr. Knebel, who is your employer?
Midland Credit Management.
And what do they do?
We purchase distressed consumer debt.
Okay, does Midland Funding service its own accounts?
Yes.
And what is your job title?
I'm a senior group manager, custodian of records.
Okay, and what does that position do?
In that position, I do a variety of data verifications as well as affidavit production oversight, as well as business records and testimony.
And what about Midland's record retention and retrieval procedures?
Yes, I'm familiar with those.
Okay. Do you know how Midland creates its records?
Yes.
Let's see. And does Midland know Capital One Bank to be a well-known issuer of credit in the industry?
Yes.
Okay, now, let's see. How long has Midland been purchasing portfolios from Capital One Bank?
I don't have the exact date, but it's been several years. We have an ongoing business relationship with them.
Okay, and does Midland purchase any accounts that have open disputes?
No.
Okay. Is this transfer made directly from Capital One Bank to Capital One's bank computer to Midland's?
No, there's a third-party server that it's placed on, and then we pick it up from that server.
Okay, and was a review done in this case?
Yes.
Does Midland rely on the information that it integrates?
Yes.
Okay. And were the documents provided to Midland at or near the time of sale?
Yes.
Okay. I now will be referring to documents that are pre-marked for identification purposes as Exhibit 1. Are you?
The documents that were filed were not pre-marked, but so just give me an idea. No, they weren't. So can you just tell me which documents you're referring
Yes,
to?
I'm sorry. The packet, you must have a different packet than me, because in my packet, they were marked, but that's.
What's
the
pre-marked? So just-
original.
Hold on. So just tell me which document you're looking at, and I'll find it.
That's what I'm doing.
Okay.
Original creditor monthly statements.
All right. And you're referring to the filing that was the witness and exhibit list that was filed on April 22nd?
Yes.
Okay. Okay, go ahead.
Okay. Mr. Nick Knebel, are you familiar with these documents?
Yes.
Okay. Could you please identify the documents for the court?
Yeah, these are original creditor billing statements that were sent out to the consumer outlining their account details for that given billing cycle.
Okay. Now, whose account do the documents in front of you reflect?
William D. Collins.
Okay, turn to the last statement with the due date of 10/5/2017. What is the outstanding balance?
The 10/5/2017, the new balance was $986.75.
Perfect. And let's see. When was the last activity on the account?
The last payment date was August 26th of 2017.
Okay, and what was that amount?
The last, the last payment amount was $100.
Alrighty. Okay, in your capacity as a records custodian, are the records Midland receives from Capital One Bank trustworthy?
Yes.
Now we'll be referencing documents that I pre-marked Exhibit 2, which obviously were not pre-marked for the court, but this is the bill of sale, Your Honor.
Okay.
If you turn to the last page of the bill of sale, can you please identify this document for the court?
The last page is a field data sheet. What that is it's an extraction of the original sale file.
Mm-hmm. Okay, and have you seen the document prior to today?
Yes.
Was it made by people with knowledge or transmitted by a person with knowledge of the events?
Yes.
And can it be manipulated by anyone?
No.
Okay, let's see. What was the sale balance?
The sale amount was $1,211.58.
And what was the amount that Midland sued for?
We sued for the same amount, $1,211.58.
Okay, let's see. Okay, lastly, Mr.
Sorry, I have a question. How did you determine $1,211.58 if the outstanding balance was $986.75? Where does the additional $300 come from?
Because that was the last the last activity was on 9/1/2017, and by the time they sold off the account, that had already accrued.
So this is accrued interest.
We don't charge interest once the account is sold off. But from the field data sheet, Mr. Knable, when was this account sold off?
The account was sold on July 19th of 2019.
So that was 2 years that through Capital One Bank, it was accruing.
All right, so it's just accrued interest for those 2 years.
Yes, sir.
Okay. All right, please continue.
Yes. Based on Mr. Knable, based on the information that Midland receives from Capital One Bank, does Midland issue statement or letters to the defendant?
Yes.
Okay, and at this time, plaintiff will be referring to documents that were pre-marked as Exhibit 3, which are letters to the defendant. Mr. Knable, are you familiar with these documents?
Yes.
Can you please identify the documents for the court?
Yeah, the documents are correspondence sent to the consumer. The first letter is a welcome letter letting the consumer know that their account has been sold from Capital One to Midland Credit Management. It gives the consumer all the pertinent information as far as contact information, as well as any balance that's outstanding, and gives them the account numbers that are associated with this account.
Okay. And what about the second letter dated 6/5/2020?
The second letter is a pre-legal notification letter letting the consumer know that their account is being reviewed internally and determination is being made whether or not their account is going to move forward in the legal channel.
Okay, and let's see. Did the defendant ever contact Midland to dispute the amount?
No, the only dispute was made at the pre-trial conference.
Okay. So based on your review of the documentation presented today, does Midland rightfully own the defendant's debt?
Yes.
Does Midland have all the rights, title, and interest to collect the outstanding debt?
Yes.
And according to your review, did the defendant ever contact, oh, sorry, that was a, let me reconvene. Did the defendant ever present any information relating to mistake or error regarding the accuracy of the account?
No.
Okay. What about the amount owed?
No.
So according to your review of the records, this amount is due and owing at this time.
Correct.
Okay, what is the total amount?
The total amount that we're seeking is $1,211.58.
Okay, no further, Your Honor.
All right. And Mr. Knable, could you just give me a quick rundown one more time, though, of the efforts made by Midland to determine that this individual is the actual debtor and not anybody else given his prior claims?
Yeah, absolutely. We do ongoing investigations of our accounts. So we do, when we initially purchase the accounts, we do data verification to make sure all the information that we receive from Capital One and integrate into our system is accurate, as well as we continuously do throughout the life cycle of an account. We do ongoing reviews of accounts. We have credit bureau notifications and a variety of different notifications throughout the life cycle of an account. And then once we're made aware of a dispute, in this case at the pretrial conference, we do an additional investigation where we personally have someone go in, review the statements that we received, review all the documentation, verify the social security number, date of birth, everything that we have on a consumer's account to make sure that there's no discrepancies within that. Once we do that review, we send the correspondence to the consumer, letting them know we've done that investigation along with copies of the statement, as well as we give them a form that we need them to fill out with any additional information that they have that can help us with the investigation.
But in this case, you never got a response to that form.
That is correct, Your Honor.
All right. All right, Ms. Schweitzer, are you moving those documents that you previously indicated into evidence at this time?
Yes, Your Honor. Yes, please.
All right, Tommy, for efficiency's sake on this, Ms. Schweitzer, you have any objection? I prefer just to call it plaintiff's composite 1. It's just easier than me having to individually label them and then hand them over to the clerk.
That is fine, Your Honor.
All right, then all documents will be admitted as plaintiff's composite 1. With that being said, I do find in favor of the plaintiff, a judgment shall be issued in the amount of $1,200. I just had it up here. One moment. $1,211.58. You said you're not seeking prejudgment interest. Are you seeking attorney's fees?
Yes, please.
All right. Was that mentioned in the submission of the complaint?
I believe so. It usually always is.
Your Honor, in the complaint, we listed not attorney's fees that we're collecting. We're just looking for court costs.
Just
Right.
cost.
Oh, I'm sorry. Yes.
All right. Costs will be awarded. There was an affidavit. Well, a notice of filing was brought. There's the affidavit. There we go. An affidavit of cost was filed in the amount of $244.25. So costs will be awarded in that amount. Judgment will accrue at the statutory rate. And counsel, if you could send me a proposed judgment, please.
Will do.
I will issue that as soon as I receive it.
Thank you very much.
All right. Anything further?
That's it, Your Honor. Thank you.
Thank you both. Have a good day.
Thanks, Your Honor. You as well.
Take care. All right. Ms. Turner.
Yes, sir.
All right. Good morning again.
Good
It's now
morning.
9:25, and the defendant is not present. I'm ready to proceed whenever you are.
Yes, sir. Good morning. Are you ready, Ms. Tickle?
Yes,
Okay, great. Your Honor, this is an account stated suit. We are going to call Ms. Tickle now.
Okay.
Will you please state your name for the record?
Hold on. Ma'am, would you please raise your right hand?
yes,
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
yes.
All right. Please put your hand down. Now, counsel, please proceed.
Will you please state your name for the record, ma'am?
It's Elisa Tickle, Tickle.
All right. And what is your association with the plaintiff, Portfolio Recovery Association?
I am a custodian of records.
Okay. And can you describe some of your responsibilities as custodian of records?
Yes, I am responsible for reviewing the accounts that are placed in the legal process for portfolio. And in doing that, I look at the accounts and make sure that all the records are accurate and up to date.
And how long have you been employed here? I'm sorry, I forgot to ask.
10 months.
Okay. And what did you do previously?
I actually worked for a credit union in Danville called Danville City Credit Union. I worked there for 30 years.
Okay. Can you please explain to the court Portfolio's involvement in the matter today?
We are seeking $1,827.93 for unpaid debt, charge-off debt.
And who is the original creditor on the account?
Capital One.
Okay. And did Portfolio purchase this account from Capital One?
Yes.
Okay. And what type of account is this?
This is a charged-off account, credit card.
Yes, ma'am. Are you currently the custodian of records regarding a customer by the name of Jeffrey Mirin?
Yes.
Okay. And do you have with you the records regarding this customer?
Yes.
Okay. And have you reviewed plaintiff's exhibits A and B?
Yes.
Were these forms A and B stored as part of Portfolio's ordinary course of business?
Yes.
Okay. And were they stored at or near the time they were received?
Yes.
Okay. Were they stored by you or someone with knowledge of them?
Yes.
Okay. Is it regular practice for Portfolio to keep such records?
Yes.
Okay. Have any of the documents been materially altered in any way?
No.
Your Honor, at this time we would move to introduce plaintiff's exhibits A and B into evidence.
When was that filed?
I see that it was filed May 24th. Do you not have that?
I don't, but
Okay.
I don't have that in front of me, to be perfectly honest with you.
Yes, sir.
And we're looking at 21 SC 748, Portfolio versus Jeffrey Mirin. So I can't rule out the possibility that I was looking at the wrong file. Let me make
Yeah,
sure.
that's correct, sir. Yes, sir.
All right. So now I've ruled out that possibility that I don't know what I'm doing. I do not see a filing. Tommy, do you see a May 24th notice of filing with the exhibits? Tommy, can you hear me?
I'm here.
Do you see a May 24th filing with the exhibits?
No, I do not.
All right. Well,
Okay.
that, and I have to say the statement of claim, you know, a lot of times all the exhibits are usually attached to the statement of claim, but that's not the case here.
Right.
Including the boarding docs.
Yes, sir.
Counsel, what would you like to do?
I mean, would you be able to just rely on Mrs. Tickle's testimony, Your Honor? I know she was able to testify to what's in the documents.
Well, on one hand, I would say no. On the other hand, small claims rules allows you for a default for his failure to appear anyway.
Sure.
So,
Yeah. I was going to ask that in the beginning, but I was like, well, she's here.
Listen, prior counsel wanted to put on all of our evidence.
Yes, sir.
I'm not going to stop her, but there is an affidavit of indebtedness
Yes, sir.
filed, and you're entitled to a default.
Yes, sir.
So-
All right. What was the default then, Your Honor?
Right. Motion for default is granted. However, if you want to review the Declaration of Custodian of Records, which is the affidavit of indebtedness that was filed May 21st, we can do that.
That's all right, Your Honor.
All right. Well, are we relying on the affidavit of indebtedness?
Yes, sir.
All right. In that case, I do find in favor of the plaintiff in the amount of $1,827.93. There was an affidavit of cost filed, so cost will be awarded in the amount of $258.50.
Yes, sir.
You're not seeking attorney's fees or prejudgment interest, correct?
Yes, sir.
All right. then interest will accrue at the statutory rate. If you can get me a judgment at your earliest convenience, I would appreciate it.
Yes, sir.
And
All
you all
right.
have a good day.
Thank you. Thank you.
Thank
Ms. Tickles.
you. Thank you.
Bye.
Bye.
All right, folks, thank you very much for your patience. I went with them first because, to be perfectly frank, usually when one party doesn't show up, it tends to go a little faster than that. So I thought I could take care of them and that way devote all of my attention to you. So please go ahead and unmute your microphone. All right, so Ms. Smith, can you hear me?
Yes. Yes, I can.
All right, good morning. Now,
Good morning.
Mr. Klein, you're signed in on 2 devices at the moment, and I can't hear you. One device seems to be connected to audio. The other one, I have the video. So the device that you have the audio, go ahead and unmute for me and let's see if this works.
Okay, I unmuted it. Can you hear me?
Yes, sir, I can. Perfect.
Okay, and I may be getting half of each. I think my cell phone's on and the computer's on.
I have half of each, but it works. It's working.
Okay.
You can run with
Okay,
that.
so we're on the same page.
Yes, sir, you managed, whatever you rigged is working. All right.
Okay.
All right, so this is 21 SC 589, Jill and Harvey Smith versus Earl Klein Jr. I did have an opportunity to read the statement of claim in this case. Now, before we get started, I didn't say this at the beginning because on the other 2 cases, there was only one party present. But I do want to say this to you because it's worth listening to. We're set for non-jury trial today. And if the parties cannot reach an agreement by themselves, I'm here to resolve the matter. I will listen to whatever evidence you wish to present. As I said, I have a general idea what the case is about because I did read the statement of claims, but obviously I don't know what the evidence is ultimately going to show. But I will consider the evidence, compare it to the applicable law, and make a determination. But what I have to warn you about is when I do that, invariably, one party walks away unhappy with the result, right? That's just an inevitable result of a trial. Sometimes both parties are dissatisfied with the result, and I can't predict what that's going to be until we reach the end of the trial. So I want to give you folks the option, if you wish, to take one more shot at seeing if you can reach a settlement. And the reason why I want to do that is this. Right now, the case is entirely under your control and the outcome is entirely under your control. If you can reach a mutually beneficial settlement, you decide what it is. It's not a win, to be sure, because it requires some compromise, but it's a guaranteed outcome that you know you can live with. You turn it to me, I cannot guarantee what it's going to be. So with that being said, let me start with the Smiths. Would you like to engage Mr. Klein in one more attempt to try to negotiate an agreement, or would you like to proceed to trial?
If we do that today, do we skip the trial and have to reschedule?
No, I would just give you a moment to speak privately. And then if you have an agreement, great. If you don't, we'll start the trial today.
Sure, I would do that.
Mr. Klein, would you like to take one more opportunity to do that?
Yes, I'll listen to Mrs. Smith.
All right. Normally I would send you folks off into a breakout room because I don't want to listen to your settlement negotiations. But given your setup here, Mr. Klein, I'm worried about sending you out and not being able to get you back in. Do you all have phone numbers you're willing to exchange with each other to see if you can make a quick phone call and try to discuss this?
Sure.
I obviously, well, I have another phone. I don't want to use the phone that my picture is on.
Okay, because you might lose the picture, right? So is there a number that they can call, Mr. Klein, that you can
Yeah,
access?
she can call me. She shall call me, or I call her.
Whichever works best.
I don't know if I have her number, but do you have my number, Mrs. Smith?
I can tell you the number that I've been using.
Well, if it's a 724, that's my cell. Let me give you a house number.
All right.
Okay.
239.
Yep.
776.
Yep.
7629.
Okay.
All right, so here's what I'm gonna do. I'm gonna mute everyone's microphone and
Okay.
turn mine off as well. When you're done talking, turn your mic back on, let me know you're ready. If you have an agreement, like I said, we're done today. If not, we'll start the trial immediately. All right.
Okay.
All right. Thank you very much. I'm going to go ahead and turn everyone's mics off now.